This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why sometimes, no matter how broad the duty to defend is, there is no duty to defend some actions of an insured. And that includes that neither battery nor failure to remove an intoxicated patron is an occurrence subject to defense and or indemnity. In Crum and Forster Specialty Insurance Company versus Spike's Pub Grub, a January 4, 2023 decision of the United States District Court for the Southern District of Illinois, Plaintiff CFSIC sought an order declaring that it owed no duty to defend or indemnify Defendant Spike's Pub Grub in a case pending in the Circuit Court of St. Clair County, Illinois. Devin Elliott sued Spike's in the underlying action and alleged that on March 18, 2021, Spike sold or gave alcoholic beverages to Corey Lyell, causing Lyell's intoxication while intoxicated, and as a result of his intoxication, Lyell attacked Elliott and stabbed him multiple times, inflicting severe injury upon Elliott. Elliott alleged Spike's was negligent under Illinois law for failing to keep security personnel on the premises, failing to remove intoxicated persons from the premises, failing to protect Elliott from reasonably foreseeable criminal activities committed by its patrons, and failing to establish procedures to maintain the safety of its invitees. Elliott also claimed Spike's otherwise was careless and negligent in providing adequate security, alleged a claim against Spike's under Illinois' Dram Shop Act, and a claim for battery against Lyell. Spike's was insured under a commercial general liability policy issued by CFSIC. The policy had limits of liability of $1 million each occurrence and $2 million general aggregate limit. Spike's sought coverage under the policy for the claims asserted against it in the underlying action, and CFIC advised Spike's in writing that it owed no obligation to defend or indemnify Spike's based on the terms of the policy. CFSIC filed a complaint for declaratory judgment seeking a declaration it had no duty to defend or indemnify Spike's under the policy. Both Spike's and Elliott failed to answer the complaint, and the clerk of the court entered default. Rule 55 of the U.S. District Court requires the clerk to enter default when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and the failure is shown by affidavit or otherwise. In Illinois, like every other state, an insurance policy is a contract, and the general rules governing the interpretation of other types of contracts also govern the interpretation of insurance policies. A duty to defend arises if the allegations of the complaint fall within or potentially within the coverage of the policy. This is known as the 8 corners rule. The court compares the 4 corners of the underlying complaint with the 4 corners of the insurance policy to determine whether facts alleged in the underlying complaint fall within or potentially within coverage. If they do, the insurer has a duty to defend. CFSIC first argued that no coverage exists for the allegations against Spike's in the underlying complaint because the bodily injury alleged was not caused by an occurrence as that term is defined under coverage A of the policy. It certainly wasn't an accident that Lyell stabbed the plaintiff Elliott multiple times. By their default, Elliott and Spike's have failed to dispute CFSIC's contention that the policy offers no coverage because the underlying complaint does not allege bodily injury or property damage from an occurrence, as that term is defined in the policy. It's not an accident. Accordingly, the court found that CFSIC was entitled to default judgment as to count 1 of the complaint for declaratory judgment. CFSIC alternatively argued that even if the complaint contains sufficient allegations to support coverage, which it did not, the policy contains an exclusion that bars coverage. The total liquor liability exclusion of coverage A of the policy provides there's no coverage for bodily injury or property damage for which any insured may be held liable by reason of 1, causing or contributing to the intoxication of any person, 2, furnishing of alcoholic beverages to a person under the legal drinking age or under the influence of alcohol, or 3, any statute, ordinance, or regulation relating to the sale, gift, distribution, or use of alcoholic beverages. CFSIC argued that the allegations in the underlying complaint fell squarely within the scope of the policy's total liquor liability exclusion. Thus, even if the policy afforded coverage for the bodily injury alleged by Elliott under coverage A, coverage would be precluded by operation of the exclusion. Because the total liquor liability exclusion applies to bar any coverage provided by the policy, CFSIC is entitled to default judgment as to count 2 of the complaint for declaratory judgment and owes no duty to defend Spikes in the underlying action. CFSIC also asked the court to declare that it had no duty to indemnify Spikes. However, the court found it is well established that the duty to indemnify is narrower than the duty to defend, and yet because the underlying action remains pending in St. Clair County, determining whether CFSIC has a duty to indemnify would require the USDC to adjudicate facts in the underlying action, which it refuses to do. Therefore, the court denied that portion of CFSIC's motion without prejudice. Although the duty to defend is greater than the duty to indemnify, even when the USDC concluded that CFSIC owed no duty to defend, it refused to rule on the duty to indemnify because the trial of the underlying action might, if some miracle occurs, find a cause for the stabbing that is not excluded. And as unlikely as that may be, CFSIC should, therefore, monitor the underlying case to protect its rights and to avoid collusion between the plaintiffs and the insured defendants. It would have been a lot easier if the trial court just decided there was no duty to indemnify either, since there was no question there was no duty to defend. Regardless, the case will go on, and the insurer will be paying lawyers to monitor the actions of the parties to protect its own interest and to avoid having to pay indemnity to the poor gentleman who was stabbed in a bar. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who logs onto the URL zelma.com/blog. And you can subscribe to the blog and receive email notification of every blog posting, and there's usually 5 a week, sometimes more. And you can also subscribe to these videos on youtube.com and rumble.com. And if you do, I'd appreciate it if you click on the like button or the rumble button, depending on which video system you view this video on. And you might also, if you found this video to be useful or interesting, tell your colleagues so that they can also see it and subscribe. And you might also be interested in subscribing to my locals community and my Substack publications, which will provide you even more detailed information on insurance claims handling, and insurance law. Thank you for your attention.